All right, so I wanted to thank the Federalist Society of both Long Island Lawyers Chapter and the Student Society for agreeing to host this event. I also wanted to thank Dean Detmlander, Nora, for taking the time to take a look at some of the issues here and in such a generous introduction of our talk for today. And of course, I want to thank all of you who are, I realize that for some of you we're standing between you and spring break, those who are law students, and so I do appreciate the effort to turn out. And I also wanted to thank my co-author John Yu, who made it all the way out from California, and this is actually, he admitted to me, his very first trip to Long Island, crossing the border into Long Island, and so it has been
might be the last.
right, exciting, and so I want to thank him for making the trek out here as well. All right, so what we'll do is I'll start off by introducing some of the big, broad concepts underlying the framework of the book, and then John will take on some of the the specific arguments we make in the context of constitutional law. All right, so in this part, I will focus on three key concepts, and I'll sort of introduce and talk about each one in turn. We go through it in the book, and so I thought I'll just go through it here for you. The three concepts are globalization, global governance, and sovereignty. And I want to define those terms for the purposes of this book, so that we are all on the same page for understanding what we mean by these terms. So let's start with globalization. I think most of you have heard or used this term globalization. For a while, they're a very trendy term, and it's sort of sometimes used to describe everything or perhaps nothing because it has so many different meanings. So let me try to isolate what we mean when we talk about globalization, and as the title of our book suggests, Taming Globalization. There are two main kinds of globalization that people talk about in the academic and public policy sphere. The first one is economic globalization, which is the inexorable, or some people call the inexorable integration of economic activity, trade, capital flows, goods, services, and we can see this. I often use this in some of my classes. How many of you wear clothing that was all made in the United States? Right? That was pure, and very few people could actually. I don't actually have people check while they're there, but they go home and they check, and very few people can actually say that they wear only clothes that were made in the United States, or that they only use laptops that were manufactured in the United States. In fact, that's actually impossible, because there are none there. So we all are pretty sort of aware of the phenomenon of economic globalization, something which has sped up. There's also, I think, we see today, resistance to economic globalization. We saw early versions of that in the Seattle protests in 1999, and some aspects of that in the recent Occupy Wall Street protests, which were focused on banks, but also banks in the global economy and concerns about their impact. We're going to broaden out the definition of globalization for us here. Economic globalization is a big part of this phenomenon, but we're also talking about globalization of social, cultural, and political affairs, and the increase in cross-border integration of social, cultural, and political activities. And so one way to think about this is that as perhaps trade and other things like cross-border, we also see, therefore, an increase in the, this notion of a social global sort of global society as opposed just to national societies, a global culture as opposed just to national cultures. We talk about, we use the phrase, the world community believes, the global values require, the international community has these beliefs. And this, I think, encompasses more than just economic globalization, but what some scholars call cosmopolitanism, right? The notion that increasingly in our globalizing world, we're less and less part of a nation state, and our national identity is less connected to a nation state and is part, to some degree, related to some sort of international community or world global community. We describe this in our book as a process. We don't say this is a good thing. We don't say it's a bad thing. Our suggestion is that it's something that's happening, sort of an exogenous, real phenomenon that's affecting countries like the United States, and our focus is on the United States. this broader sense of globalization in particular is also leading to increasing calls for something called global governance, which is the second concept I want to talk about today. And so our focus is on globalization, not so much to talk about globalization, this is good or bad, but to focus on the consequences of globalization for the United States. And so here I'm just going to use a quote by former International Court of Justice President Rosalind Higgins, who has remarked, globalization represents the reality that we live in a time when the walls of sovereignty are no protection against the movement of capital, labor, information, and ideas, nor can they provide an effective protection against harm and damage. Encompassed in this idea, which I think is shared by many, at least many scholars and also many policymakers, is that globalization is leading to the erosion of the nation state, or at least it's somehow threatening, or at least necessarily requiring us to rethink the nature of states and what they do, and their independence and their ability to be sort of independent of the international community or of each other. Global governance is a term we use to describe this sort of this belief that, this trend that we need to create international or global institutions or global mechanisms to coordinate states and sort of non-governmental organizations to try to create some sort of mechanism for coordinating and dealing with international problems, or perhaps to give sort of effect to some of the global values that perhaps have risen as a result of globalization. The two things that we describe, we focus on in the book as the main consequences of global governance for the United States are the increase in the type and nature of international organizations and changes that we've seen in the nature of international law. Okay. So let me just start with international organizations because I think it's a little bit more easier to get your hands on. It's often what we think about here. International organizations, of course, are organizations created by states. What's new or different about international organizations today, as we think, as a consequence of globalization, is that international organizations have a different role, perhaps, and they have two characteristics that are relatively new in human history. International organizations are increasingly, they are independent of nation states. They have a certain amount of independence from nation states. And they additionally have acquired more and more what we normally would think of as sovereign powers. They have powers to regulate people directly rather than regulating nation states. So to give you an example of this, I'll give you sort of two sort of spectrums of two different kinds of international organizations. One which is a traditional international organization has very little sort of, I think, non-example is the example of the old system, and then one which is sort of an example of the new system. So the old kind of international organization would be sort of the bilateral commission. The United States has been members of these since its early history. One example I always point to, and some of my students here have probably heard this, the United States-Canada Border Commission is designed to just deal with border disputes between the United States and Canada. It's an international organization, but it doesn't have that many powers. It's not really independent of the two states. And it's a type of international organization that is created to resolve simple or bilateral interstate disputes. An international organization that's much more ambitious scale would be something like the International Criminal Court, which is empowered by nations to directly prosecute individuals who have committed certain crimes who come within their jurisdiction, and also to demand that states turn over individuals if they are unwilling or unable to do so. The International Criminal Court is an example of a much more ambitious and much more independent international organizations. The judges and the prosecutors are not responsible to the nations that appointed them. They're intended to be independent. And so this is, I think, an example of the type of trend that we're seeing today. More and more organizations that are closer to the ICC than they are to the US-Canada Border Commission. And that there's a notion that in order to deal with global problems, with globalization, in this sort of new world we live in, we need to create more international organizations, or rely more on them. And in fact, the world is creating relying on international organizations. And relatedly, the nature of international law has also arguably changed. And this is a longer change that's occurred over a longer period of time, but has a particular impact now. International law used to be, and my students here have heard me tell them, traditionally about the relations between nation states. It regulates relations between states. But increasingly, international law has become about also, in addition to that, regulating the relations between states and their own citizens, or directly regulating individual people rather than just states. And then international law has increasingly gone into subject matters that were traditionally left to domestic affairs. So this new international law is also, I think, one of the consequences of globalization, right? We live in an interconnected world. We need to have more uniformity in our laws. We need to have international organizations to administer these laws. This is not, I hasten to add, a claim that there's some sort of world government being created, and here, I'm not just, some of you may remember a guy named Pat Buchanan who was always concerned about, threats to national sovereignty and global governance, but there's a tinge of like that there's some secret conspiracy. There's no conspiracy, this is just real trends that we see in the world that's happening as a part of, problem by problem, countries get together and create international organizations. Okay. But we do think, and this is where we get to the argument of the book that the Dean mentioned when we these trends in global governance really are creating questions about the nature of sovereignty. And sovereignty has typically referred to the sovereign powers of nation states and the absolute sovereignty, perhaps, of states and their ability to control their own affairs. And national sovereignty, and absolute sovereignty, which is the classic conception of sovereignty, is definitely something that's hard to maintain, at least in its classic form, in this age of globalization, in an age when we're interconnected, in the age when we have international problems and a global elite and global values as opposed to just national values. It's at least, in the era of global governance, sovereignty is perhaps, as our Judge Higgins suggested, breaking down, unable to be maintained to solve all the problems that we face in the world today. Our view in this book, and some people are a little surprised perhaps, is that, again, we're not resisting the notion that we'll have more global governance in the future, or even suggesting it's always a bad thing, but we are insisting that the benchmark for measuring how their relations will be with the United States is the Constitution, and that the Constitution should be the focus of regulating the United States' relationship with international organizations, with the new international law, in order to balance two interests. The interests of what we call popular sovereignty, or the sovereignty of the people of the United States as reflected in the Constitution, to balance that against the very real needs and interests of the global governance movement. The Constitution, we think, can serve as a mediating mechanism to control and regulate, and also to protect the basic sovereignty, what really matters about the sovereignty of the United States. We think it actually will help, in some cases, make it easier for the United States to make credible commitments to international organizations and to participate in global governance. But in other cases, we think also it might not. But we argue that the Constitution should be the focus and the guarantee of what is sovereign about the United States. So that's my spiel, and I'll turn this over then to John to take you through some of the particular constitutional issues.
I'd like to thank the Federalist Society for inviting me to come speak, and I'd also like to thank my classmate Nora for introducing me. Nora, I guess you all know, is from Germany originally when she came to law school in the United States, and she always concerned me as a student because she was always sitting in the back of the class and had done all the reading, because I could peek over into her casebook, and she had underlined and made notations. I actually looked up the footnotes and cases and read the law review articles that the authors had cited, and then she never spoke in class. Right? And so actually I have to say that the introduction she gave is the longest I've ever heard her speak in a classroom. But those are the ones you always worry about in law school in terms of how well they're going to do on the exam, are the ones who are furiously studying and they never say anything in class. So I always used to, and then we served on the law journal together, which was a wonderful experience. And it's just great to see her flourish. I also want to say that's the nicest thing any dean has ever said about me. Certainly my dean thinks of me as just an unmitigated pain in the neck. So I'm constantly causing him trouble on how to define the competing First Amendment rights of myself and protesters. So thanks very much. It's great to see you after all these years. I also like to thank Julian for inviting me to speak here and for co-writing a book with me, which I could not have been a pleasant experience. Julian, I've always wanted to have a co-author who has a name that rhymes with mine and looks somewhat like me, so that if anyone tries to give me a hard time, they might get confused with the targets and pick him rather than me. Also, Julian's a little bit more burlier than I am, so he can defend himself better than I can. We had an event in New York City last night where some guy tried to arrest me with a pair of handcuffs. And this is one of the more intelligent protesters I've had over the years. The last Federalist Society event I was at, a guy showed up in a Darth Vader outfit to protest me, but he didn't know what I looked like. This is part of the strategy. And so I actually went up to him and I had a picture taken of him, and he was like, "Oh great, come right over here, let's take a picture." And he realized that I was the guy who was there to protest. And then I assured him that I loved his outfit, because in all the Star Wars movies, I always root for the Empire. I hate the Jedis, because you know who the Jedi, does this make sense? The Jedis always remind me of federal judges, right? They run around the universe with an unclear right to interfere, and they wave this shiny thing around, and they use the Force, and they get everyone to do what they want. They have little immature versions of themselves following them around who are like law clerks, and they interfere with parliamentary democracy. I mean, so I've never liked the Jedi in any of the movies, but I digress. Also, I'd finally like to thank Professor Friedman, who's the moderator, who's, I have to say, whose work on the Great Writ I have long admired and have read thoroughly. We disagree on it, but I would be the first one to admit that he won and I lost when it came to predicting what the Supreme Court was going to do with all the habeas cases out of Guantanamo Bay. So it's a pleasure to be on a panel with him. And then finally, thanks to all of you for coming and showing up, because Julian told me in the car ride over that you were all just about to embark on spring break, and so I apologize for delaying your arrival in Cancun. But I have a lot of experience at this because I teach at a law school in California where the students seem to think every day is spring break. So we have sometimes trouble enforcing not a dress code, but dress in the classrooms in California. Anyway, let me just talk a little about substance. I could go on at length about all my strange observations of getting here and everything. But so let me just pick up where Julian ended, and then I'm sure you'll be happy to take whatever questions you like or comments. So from the constitutional perspective, one reason that I think Julian and I sat down and wrote the book together is because we had this common impression of what was going on with globalization. That globalization reminded us a lot, and I think it's quite apropos that we're talking about this on the week that the Supreme Court was hearing arguments in the healthcare cases, which are really testing the limits of the New Deal state and how far the Commerce Clause goes and so on. When we thought about globalization, we were struck by the similarities to the New Deal, the Great Depression, and the response, and what's happening now with the response to globalization. We're just a lot earlier in the process. But if you think about your constitutional law classes, I trust you went over the New Deal and the confrontation between President Roosevelt and the court. One way to think about why that happened, and it turned out terribly for everybody involved, the Supreme Court, President Roosevelt, Congress, everybody lost in that battle. You think what happened was that nationalization had occurred in the United States in the 30 or 40 years preceding the great fight between the court and the president. And constitutional law was unready for it. Right? Constitutional law doctrine was still designed for a time when the economy was not unified and nationalized, where goods and products couldn't move quickly and easily around the country. And so what happened was, in response to the Great Depression, the political branches wanted to create a system that expanded the Commerce Clause to enormous lengths, to the point where the federal government could regulate a farmer, or this is Wickard versus Filburn, a farmer's personal use of 257 bushels of wheat. Now I bet there's probably no one here who knows exactly how much 257 bushels of wheat are, because we're living on the East Coast. And when I teach the case in the West Coast, no one absolutely has any idea how much 1 bushel of wheat is. But I was just in Kansas on Monday, so I finally got to ask people, how much is 257 bushels of wheat? And they said it would fill up a small pickup truck. So that's how much wheat there was, subject to the case of Wickard versus Filburn. So that just gives you a sense of how far the Commerce Clause was pushed to regulate national economic affairs, how granular it got and how far it had to go. The second big development from the New Deal was the creation of independent agencies. That if you're going to create broad national regulation of the economy, you would want to create agencies that were independent of politics and would use technical expertise to regulate under those vast grants of power. Right? If you remember your constitutional law history from FDR's first and second terms, the Supreme Court essentially blocked both of those efforts at innovation in the government until, remember, President Roosevelt threatened to pack the court to add, I believe it was 6 new members to the Supreme Court in order to get it to change its mind. President Roosevelt, if you remember, wasn't very upfront about the reasons why he was doing this. Everyone knew that he was doing it to get the court to change doctrine, but he said it was because there were too many old justices on the Supreme Court. This made, it seems like things never change, does it? That for every justice over 70 years old, he should get to appoint another justice, because he wanted to appoint younger assistant justices who were going to help the older justices understand how the real world worked, that we were no longer what he called the whip and buggy years of the economy. As you remember, Roosevelt's plan failed, but while it was being considered in Congress, the Supreme Court changed directions radically on both the questions of broad powers of the economy and independent agencies. And so we've had both, but at the same time the court lost a great deal of its legitimacy. President Roosevelt was never able to put into place more New Deal programs after that great fight. An argument is that we're seeing the same things now with globalization. And that part of why we wanted to write this book was to try to prevent any kind of massive confrontation that really distorts constitutional law because we don't think about the problems beforehand. So you see in the proposals for dealing with globalization that Julian was mentioning, some of the very same ideas that ran behind the New Deal state, but taken to a much higher extreme. So, for example, a treaty to control global warming would have to impose energy usage quotas, pollution quotas on every nation, which would have to reach into the amount of energy individuals use, which is something actually that the federal government has not yet done. It's placed, for example, mileage per gas limits on cars when you buy them, but the government hasn't tried to regulate how much energy is used by individuals in their homes, for example.
Yet.
Yeah. Well, yeah, maybe yet. We'll see how it comes out of the Supreme Court this week. But that would be, I think, actually a sensible exercise of the treaty power from a policy perspective if you wanted to really control the amount of energy that's used. And you would create an international organization that would not just be neutral and designed to perform make decisions based on technical expertise, but that would be independent from the control of any nations. So you have already a number of areas like the Law of the Sea or the World Trade Organization, Chemical Weapons Convention. You already have the creation of these kinds of agencies and tribunals. They're specifically designed to resolve disputes, interpret law, and even try to enforce them, but without being subject or accountable to any single nation. Our argument is that that allowing that to happen without any kind of mediating check or participation by the branches of the U.S. government, particularly those that are elected, the presidency and the Congress, would run counter to the idea of popular sovereignty that Julian mentioned. That the thing that makes the United States different from other countries, particularly those in Europe, is that sovereignty in the United States isn't vested in the idea of a country that's independent of the people. That here, the American people only allow the government to exercise a sovereignty that's granted to it in the Constitution, and that the Constitution is a contract between the people and the government, and that it doesn't, the federal government can't lay claim to more powers that are in that contract. Just the way in corporate law, the shareholders only grant a limited amount of power to the managers, and managers can't do anything else than what the shareholders permitted in that corporate charter. So we don't think, we're not, for example, saying that international law has no force, or that the United States shouldn't participate in international institutions, or that international law itself doesn't even exist, but that in order for the United States to participate and cooperate at the international level, it still has to do it through the same constitutional processes it uses to make regular government decisions: passing of legislation, interpretation and enforcement of law by the executive branch, determination of disputes in cases by the federal courts. But that if we do it that way, then we still honor and maintain our constitutional system, and we avoid, I think, and here I'm going to speak beyond what the book says, because I don't know if Julian agrees with this or not, but I think it avoids the problems that Europe is having. I mean, in my view, if you read the scholarship about the European Union, they have a big problem, which a lot of them call the democracy deficit, that you have a lot of decisions made by a supranational institution that has no responsibility or direct accountability to the population. And that the European Union authorities exercise sweeping powers within the Union, but there's a gap between that and what the people want. And you're seeing the effects of that right now. And I think it's an open question whether the European Union is going to survive in its current form. So let me turn now and just close with three practical doctrinal applications of our effort. One, as Julian mentioned, non-self-executing treaties. And this is the idea that I think the court upheld in Medellin versus Texas, which was just, which Julian also mentioned, and Dean Ben Leitner mentioned. The idea that treaties should not take direct effect in the United States until Congress passes a law figuring out how best to implement the treaty. So you remember in Medellin versus Texas, a Mexican national who was convicted of first-degree murder was not given warnings under the Vienna Convention. He was given his Miranda warnings and received what the court said was a fair trial in the state court system, and he received his right to habeas corpus. But he didn't receive the warning under the Vienna Conventions, which essentially said he had a right to meet with his consular officials and get the help of the embassy from his country. And we had 3 go-arounds with the International Court of Justice about this. The United States admitted that it had violated the treaty in Medellin's case and in a number of other cases. The International Court of Justice then tried to order the United States as a country to stop the executions, which both the Clinton and Bush administrations did not do. It then ordered the Supreme Court of the United States to stop the executions. And you know, any of you who've studied the U.S. Supreme Court can imagine what they said back. Nobody tells the Supreme Court what to do. And then they tried to get the president, and President Bush, and this is what gave rise to Medellin versus Texas. President Bush actually issued an order directly to Texas, to the governor of Texas. I think he remembered the mailing address, to stop the execution. And the Supreme Court said no, not until Congress passes a law deciding how the United States would live up to this Vienna Convention right, would the courts or even the executive branch have the right to create this sort of freewheeling federal law. And we think that's the proper way for constitutional principles to be honored, because then the most popular elected legislative branch, which would normally pass domestic rules about the criminal justice system, would also pass those same rules when it came to a treaty. The second doctrinal principle we recommend is that the courts largely defer to the other branches of government when it comes to the interpretation and enforcement of international law. This is raised by a case that's going on right now at the Supreme Court called the Coble, I think, versus Royal Dutch Shell, which asks whether corporations can be jointly liable with governments for violations of international law under the Alien Tort Statute. And the court heard briefing and arguments in the case, and then, and then a very unusual step, I can't remember the last time this happened, it actually sent the case back to the parties for rebriefing and re-argument next term on a much broader question about whether the federal courts even have jurisdiction to hear these cases when they involve events and parties that happen wholly overseas and don't involve any Americans. Our view, though, is that this litigation, which has primarily been a product of the federal courts in New York City, I mean, they were the first courts to do so, and they've been the most aggressive courts in pushing the Alien Tort Statute cause of action. Our argument is actually that the courts in hearing these kinds of cases, similar cases, should look to the executive branch and Congress for guidance on what norms of international law should actually be heard in court and what those norms mean. In part because we rely on those other branches to make the fundamental decisions for the country about foreign policy and about international politics, and that now that international law is such a fundamental part of those, that the court should similarly give space to those branches for the use and interpretation of international law so that we don't have multiple inconsistent views being expressed by courts, especially because courts we think are very poorly designed to set national policy, particularly this kind. The last proposal, and this is really Julian's area specialty far more than mine, is to call on the states to play a more reinvigorated role in foreign affairs. In part, we think this is inevitable because of globalization. Because globalization affects all different parts of our lives now in a way it didn't, say 50 or 60 years ago. It's hard to say that there should be exclusive federal control over foreign affairs when foreign affairs affects everything. You just think, everyday life, Julian's example of where your underwear comes from, right? Which is, I never really asked that before about where my underwear came from, and I don't care what happens to it after I'm done with it either, I suppose. But bigger question, like child custody, there's international norms about child custody, family law, education, religion. It's because of globalization, many of the things that states are still the primary regulators of, have still reserved powers under our Constitution to control, affect international affairs now, and are affected by international affairs. And it can't be the case, we argue, that the federal government can oust the states out of all of those events, laws, cases, rules, where international affairs are now involved. And so instead what we would say is that if the states still regulate an area, now they should continue to do so unless Congress and the President agree on a law that's necessary to impose some kind of national uniform rule. So in closing, and before I turn it over to the moderator, we actually think that this, as a matter of consequences, would be better for the country in its participation in international affairs than the current state of things. Because now, we think the United States will has and does sign on to agreements, treaties, codes of conduct, what have you, without sometimes serious intention to do anything to live up to it. We overpromise when it comes to international affairs. If instead the United States, when it signs on to a treaty or decides to follow some rule of international law, it then goes forward and undertakes the difficult domestic process of passing a law or implementing and enforcing a certain norm, that means the United States will be far more committed to keeping with that norm and keeping in that international regime and obeying that international system than is currently the case. And so we think that actually the United States will be able to cooperate, maybe not as broadly, but far more deeply than it does now in regulating international affairs that arise because of globalization. So thank you very much, and turn it over to Professor Friedman, who's the moderator.
Thank you. Thank you both, and I want to say to all of you, this does not mean that you're not supposed to buy the book. You're still supposed to buy the book. You may be wondering, as I was wondering, precisely what my role here is, and I figured it out. They put me up here in charge of calling on you for questions, which of course they could as well do for themselves, because that way I don't get to ask them all the questions that I would otherwise have, and instead we get to hear from all of you, which of course is as it should be. So.
You should ask one question first.
Yeah,
only one. With 10 of them.
one for each.
Everything's a negotiation.
No, I actually was just thinking that some of the it's plainly true that the intensity, the speed and intensity of the forces that they're responding to have increased in recent time. But it's not true that these things have never existed before. The Roman Empire was very eager to be accepted among the nations of the civilized world and be accepted by the Phoenicians and others who were the dominant powers then, being crude barbarians and not conforming to the norms of civilized people. They were very, very eager to be part of the global community and be recognized that the stuff that they did was civilized. And so too the independent agencies long predated the New Deal. And they came about starting in the late 1800s and early 1900s. The ICC, the FTC, the FDA, all created to bring neutral expertise, somewhat independent of politics, to bear on controversial issues as technical things got more and more complicated and were thought to be beyond the ken of politically elected people and should be turned over to more neutral parties, which would necessarily mean less popular input, but sort of ultimate democratic control. So I guess what I would say is the concept that the pre-existing frameworks for all of these things have to be seriously reorganized may be somewhat exaggerated. Anyway, okay, enough. Let's ask somebody else, and you'll get to respond when you respond to them. Oh, sorry. Otherwise you and I would just wind up talking, and that would be.
Can we give
Yeah,
our
go
guests,
ahead.
give our guests
Well, I actually wouldn't mind talking about the Romans and Phoenicians, but because actually the book I'm working on now is because I worry I'm not getting controversial enough. So my next book's on preemptive war, international law. I actually just think I'm going to call the book Iran and make it in red letters.
It's good for your search engine.
Yeah, exactly. But so I was actually reading a lot about the Punic Wars and how the Romans, they did, I mean, just as the Romans did have some concern for international law, but when they decided to wipe out Carthage, they didn't sit around and wait for a just cause, for a just war. They just did it, or they would manufacture excuses to claim that they'd been attacked first when everybody, including themselves, knew they had not. I don't know if that reminds anybody of anything. But with independent agencies, I think you're quite right. I mean, independent agencies do arise at the end of the 19th century with the Interstate Commerce Commission, and then the Federal Reserve Bank as a even a bigger change with under President Woodrow Wilson. But they're never upheld as a constitutional matter until Humphrey's executor, I think. I think that's right. In fact, the case law, it seemed to be before Humphrey's executor, was Myers, which actually seemed to suggest independent agencies might be unconstitutional. And so it's really not until the big confrontation between FDR and the Supreme Court where you really have a constitutional resolution of the place of independent agencies that holds pretty well until the 1980s, and the Reagan administration then tries to get them tossed out again. So I do take your point. I mean, it's not that independent agencies just sprung forth from the head of Zeus to regulate in the wake of the Great Depression, but they get supercharged, really, I think, in numbers and jurisdiction as a result of the New Deal's effort to respond somehow to the Great Depression.
Let me just jump in and add one thing. And I think we see that international agencies do have some characteristics that are a little different from U.S. agencies. They're not subject typically to the appointments or some other controls that we might have in the U.S. system. And we see, I think, just to take one of John's earlier points, we see this a little bit in Europe. The primary justification for the expansion of the EU administrative state is to resolve a lot of these technical sort of issues and to take it out of the nation states of Europe. But this is actually, I think, this idea that they could create these specialized agencies without, I think, sufficient political support, which effectively dominate, I think, some people estimate more than half of all laws in any EU country are generated out of the EU system now, rather than out of the individual nations. I think the mistake, at least from my perspective, is that the EU did it about the wrong. They should have actually created a political framework to justify the administrative state, rather than start the administrative state and then say, well, in order to have administrative state, now we need to have the political framework. I think we want to kind of make sure we start with a solid political base.
Yeah.
Should I get the mic or should I just?
Yes, you better come someplace where the rest of the world can hear you.
We can hear you from the seat.
You can hear me from there?
Okay.
I'm not.
Yeah, otherwise we'll be.
All right. Okay. You were talking. Oh, I'm Nancy Gamby, by the way. You were talking about how they wanted to regulate our electric, and that came down from the UN. That was the Earth Charter, which was Agenda 21 that was brought forth by Maurice Strong. And when you were saying about the NGOs, they have extreme power. You had one of the NGOs that came out of the, well, from the Earth Summit, which then became the Earth Council, called ICLEI. It's I-C-L-E-I. Now, ICLEI, one of the main jobs was to promote worldwide local Agenda 21s in all the local municipalities. And if you, right now, through the American Planning Association, if you look at all of their framework for the planning that's in all the United States, in all the local towns, all across the country, they are following Agenda 21 procedures. All the smart growth, all the high-density housing around the train stations, that all fits right into Agenda 21. If you go back and look exactly what they were regulating. And so I find it's extremely dangerous to the sovereignty of the United States that through the NGOs, the UN can infiltrate the United States. And our Congress did not vote on it. You had George Bush Sr. did agree to it, but it never went through Congress. And then you had Clinton, and you had, I'm sorry,
Bush.
I'm sorry,
Bush
Bush,
Jr.
thank you. No, Bush Jr. didn't sign it. Bush Jr. didn't sign on to it. But it was never approved by Congress. So here's a situation where Congress did not approve, and no less the United States is implementing it now. And I find that of great distress to our country and to our Constitution, and I find it's at great peril, and I would like your opinion on that.
Well, I kind of have a mixed reaction to that because you're right. I mean, one of the burdens of our book is to point out that there are international norms that sometimes it's not through a formal international organization, but in fact it sounds like the way you describe it, through a non-governmental organization that's affiliated with international organizations that promotes norms, right? That promotes norms. So it's kind of like a backdoor, right? Now from that perspective, I think, on the other hand, since we are sticking with the Constitution, from our perspective, there's nothing that would prevent localities from choosing to adopt these norms. And in fact, we think that if locality, it would actually be, if they are being pressured or coerced into it, it's actually, sorry, maybe I'm misunderstanding, but then actually then we don't find that, we actually think it's, more diversity. So if Berkeley, California, which some people think is a little bit more liberal than other parts of the country, would want to ban nuclear weapons, that's probably okay. I mean, if some other...
Berkeley has banned nuclear
weapons. In fact, they have, right? So, but if some other district wants to have them, I mean, so that's part of our thought is that we do think it's really important, though, that to the extent you adopt a legal binding rule that would coerce governments or that would bind through legally binding mechanisms or bind localities, then I think that's where we think it's important, like you mentioned, to really insist upon Congress or a politically strong framework to justify the adoption of these international norms. So, I mean, perhaps I'm misunderstanding. I don't know if did you want to clarify or?
It's being done through the federal agencies.
It's being done through the federal agencies. The American Planning Association had a 1,500-page planning guide that has their definition of eminent domain is to use eminent domain to remove a nonconformity. Well, a nonconformity is one that doesn't conform with the plan, a redevelopment plan. Well, a nonconformity can just be a gas station that's there, that they don't want anything to do with cars in the plans. All the plans I've seen across the island. And what they're doing now with the block grants and everything coming down from the federal government between the Department of Transportation, HUD, and the EPA, they're doing these mega block grants. So it's all this free money to the municipalities to implement the smart growth from Agenda 21. So it's not necessarily that you have to do it, but you're giving people a lot of money when they're cash strapped. So it's coercion in
with a carrot, not a stick.
Okay, well, I mean, that's a hard. In fact, the Supreme Court was thinking about that question just this week about to what extent the federal government uses money to coerce. I mean,
coerce by giving you yet more money.
I mean, that's something we haven't quite talked about in this book. I mean, our main focus is on legally binding rules, but I think you're right that certainly norms can be spread very powerfully through these sorts of mechanisms.
And indeed, when the national government, as opposed to international agencies, want to deal with issues of state concern like family law, criminal justice, so they do it through federal funds. So, anyway, yes.
Oh, I wanted to say something.
Okay,
okay, no, it's okay. So, excuse me. First, I actually, we didn't know about this when we wrote this book, actually. This question has come up in a few fora now where we've presented this, and so it's really interesting to learn about it. It's something I haven't come across in scholarship and so on. But what I would say is one concern that I would have, I don't know if Julian shares it, is that that any locality or state think they have some legal obligation to carry out some kind of plan that comes from an international source unless it passes through some popular approval in our constitutional system, Congress, a state. So for example, a state could pass a law that mimicked or copied the principles out, but it still has to go to a vote of some kind of democratic process. So if it doesn't, that one raises concerns to me about the popular sovereignty ideas behind our Constitution. The second thing, and this goes to something you said about the presidents and what their position had been, especially when it comes to federalism, the Constitution does have this 2/3 requirement for treaties, and the framers put it in there in part, I think pretty specifically, so that states could protect their rights and federalism when it came time to make international agreements. And so if there are international agreements that we're entering into that actually do start to go to areas that come under state control, those are the ones I think that the framers really thought should go through the treaty process. And actually for other reasons we think that solves some other problems like the Missouri versus Holland problem. But there is a phenomenon that's been occurring by presidents of both parties for many years now, which is where presidents voluntarily, say in the international political realm, we will voluntarily follow some kind of international agreement, but won't submit it to the Senate. And so I wrote a piece with John Bolton a few weeks ago about this going on with the European Union's Outer Space Code. Believe it or not, there is a European Union Outer Space Code. Somehow the New York Times agreed to publish it, maybe because they forgot what it was, I don't know. Because generally, maybe it was because of Bolton, I think is actually the real reason. But you have presidents who, because there is this loophole in international law, I think it's a loophole, at least for our political process, which is if a series of countries agree to follow some kind of norm of a certain period of time, and they say they think it's a legal obligation. It coalesces at some point into customary national law and actually assumes a position in international law that's higher than a treaty. And so I worry when presidents, again, if both parties have been doing this, that presidents might enter the United States into this kind of binding international law when it never underwent the treaty process in the Senate. So if that's happening here too, then I would also be worried that this is sort of an end run around the treaty process, but we'd have to wait and see how long this went on for.
Yes. Professor Yu, you went on at length about the, I would say, correlation between the expansion of the Commerce Clause and, I guess, the rate of globalization. So in light of the Lopez decision and Rehnquist's, I guess, pushback, plus what's going on now with Obamacare, where do you see that going in the future?
Well, when the other area I actually used to write about was federalism and judicial review. Before I worked in the Bush administration, I tried to write about two subjects I thought were relatively backwaters in constitutional law. So I wrote about war powers, and I wrote about federalism and judicial review. And neither of them turned out to be backwaters in the end. But that's how you get tenure. You try to write about things that are uncontroversial and no one can give you a hard time about. So that was, plans never work out the way you think. So, one thing is, I think that with what the Rehnquist court did, which the Roberts court, hasn't really carried forward yet, as far as as this kind of federalism revolution. But to me, it's just really nibbling at the edges of the great expansion of the Commerce Clause that happened at the New Deal. I don't think that the court has actually struck down any significant piece of legislation as going beyond the Commerce Clause. It hasn't struck down any of the environmental statutes. It hasn't struck down any employment or economic statutes. It struck down, basically three things, right? The Gun-Free School Zones Act, which the court in the opinion said could have been done constitutionally a different way. The Violence Against Women Act, one provision of it, which made criminal crimes which are already criminal in all 50 states, and no one got particularly upset after the court's decision striking it down. And then the amenability of states to suit for damages in federal court for violations of statutes that were passed under the Commerce Clause but not under the 14th Amendment. To me, these are not any serious threats to the New Deal administrative state that we have that exists under the Commerce Clause. So, two, under Obamacare, seems to me that if the court strikes it down, and I think there's been an unbelievably quick shift in expert opinion about whether this is going to happen now after the oral arguments this week, which, although people don't seem to understand that oral arguments, especially in important cases, mean almost nothing. And the justices are probably going to make up their minds no matter what arguments were made in court this week. The court could strike down the individual mandate and still leave all the rest of the Commerce Clause jurisprudence and the New Deal state intact. And I think that's probably what they would do, even if they did strike down the statute. Because all they would be saying is that the Congress can't force you into commerce. If you want to enter commerce, then they can regulate the hell out of you. And sometimes they do. But they can't make you go. That's not going to affect any other, as far as I know, any other federal statute that exists. Right? Both parties seem to agree that this is the first time Congress has ever done this. So, striking down, so in that way, it might make it easier for the court to strike the law down. I don't know. The third thing is, this brings it back to the book's themes, I think, is that no matter what happens with Obamacare, we can't escape this issue because entering into treaties to regulate globalization are going to go even farther in regulation than what we've seen, I think, so far from the New Deal state. For example, examples of global warming. In fact, the justices in a federalism case had an argument about could the federal government under the Commerce Clause regulate energy usage for global warming purpose so far as to bar everyone from burning fire in their home fireplaces. And there was, I think Justice O'Connor said no, and I think Justice Breyer said yes. So I think as we keep going forward in this period of globalization, regardless of how Obamacare comes out, how the Supreme Court decides on Commerce Clause, you're still going to have to face a question yet again.
Yeah, I
Hi, Senator Turner. My question's directly, obviously for both of you, but directly toward Mr. Yu. I heard you talking about in your, as you were speaking about the contract, the Constitution, how the people and the federal government, and how the federal government's not supposed to exceed its powers. Well, directly, you were the author of the torture memos, which, you know, talk about having or doing torture on foreign terrorists who aren't from this country if they're suspected terrorists in this country. So I have a couple of questions for you.
Well, first let me just say, it's only, first of all, I don't think it's torture. You could call it torture. The whole memo is about what is or is not in my view. But second, it's only about terrorists who are not United States citizens or permanent resident aliens who are outside the country during wartime. I never said that the United States should go around abusing people within the country who are citizens. I just want to be clear about that.
Okay, but my question is to you. If you take an American and they go overseas and
then we kill them with a drone, say.
If they're suspected of terrorism, just suspected of it, and another country does that same interrogation that you use on the foreign terrorists here, would that be okay in your eyes?
Well, let's make it harder. Suppose there's an American citizen abroad we think is a terrorist and we kill him with a missile. And we do it. Not even another country does it. Do you think that's constitutional? I think this current administration thinks it is. And many people who criticized us when we were in the Bush administration seem to have lost their spirit for civil liberties all of a sudden. And it seems to me a far greater deprivation of civil liberties to kill American citizens who are suspected of being terrorists rather than capturing alien terrorists who everyone, I think, agrees were involved with the 9/11 attacks and wanted to commit further ones against us. And to interrogate them, and I agree we interrogate them harshly, but we did not kill them and the innocent civilians who are around them. So one thing I'd ask you is which one is the greater deprivation of civil liberties, and whether you would apply the same criticism to the current administration for that policy.
I agree, but I'm asking you because you work in the Bush administration. Does it exceed federal government power?
No, I don't. I mean, obviously, I don't. Obviously, I don't think it does. I think, what else, I mean, I can go to length, but I think in wartime, the president is the commander-in-chief. If the United States has been attacked, as it was on 9/11, the Constitution gives the president the power to conduct a war against our enemies. Now, Congress can try to prevent the president from exercising those powers in the way he sees fit. I don't think Congress can make it criminal certain presidential decisions on how to conduct the war. It can cut off funding. It doesn't have to provide them with certain military units or pay for the military at all. But I think that the Constitution vests the president with the authority to run the war. Now, you may disagree that 9/11 was a war. I tend to think it was. You may think that this is unprecedented, but I would say go look at what President Lincoln did during the Civil War. I'd say actually President Lincoln exercised constitutional power as broadly or more broadly than President Bush or President Obama have in the war on terror. So I don't think that this was beyond the president's constitutional authority.
Yeah. Wait, in the back row.
Yeah, so we've seen a lot of game changers in the last decade or so with things that we deal with domestically and abroad, hence our discussions in globalization and a lot of the things you guys have been discussing. I was wondering what your concept, if you have one, would be for whatever entity it would be the vetting process for entering into these potentially entangling alliances or treaties with international organizations would be. And secondly, aside from the perception that might be given to people who are entering into these treaties with, if you thought maybe a kill switch would be more capable of dealing with arising changes in these, ever-changing times. Like tomorrow, something could happen that we've never seen before, and all of a sudden, this globalized community has to band together and do something. I'm just thinking, what is your ideal concept of the vetting process, and do you think a kill switch would be better?
Just so you're clear, when you mean kill switch, you mean a way to shut down the international organization?
Sure. So, for example, if necessity dictated action, my fear or concern would be that as politics have become stagnant, and we see this every day today, that maybe what needed to happen couldn't get done, and we'd be in a situation where someone overstepped their powers or whatever. So, what do you think would be better? I understand that perception to people who be entering into these treaties would be, well, they're just going to, a kill switch would be like, well, what's their word worth? But to me, I'm just trying to balance necessity of action, versus a convoluted political process, the vetting, potential action?
Well, I think this is related to, I think there's a time and place for complex vetting, and I think we think, generally speaking, this is how we make laws domestically, right? We go through this really painful and elaborate process for making rules that govern us here. And so the basic argument of the book is that in almost every case, to the extent we're making rules governing our actions and affecting our domestic activities, even if they're driven by some international necessity, they should, as much as possible, adhere to the same process, the same painful, ugly process. We need to live with that, and we think, and we actually argue that's actually a good thing. So that's the main argument of the book. I think one interesting thought about getting out of treaties, and this is interesting, our argument suggests that actually it might be a little bit harder in this sense. To the extent we demand or insist on statutes or Congress to implement things through the law, it actually means that, because it's actually arguably easier to get out of treaties, the president arguably can withdraw from the treaty, for instance, on his own authority. But if we go into it with a substantial commitment such as Congress is implemented by statute, it's actually harder to get out. But we balance that against, I think, in my view anyways, the benefit of all the deliberation that occurred before you got into it. I don't know if you have any thoughts on that.
I really have something about the second part of your question, which was more about what happens if there's some new, and correct me if I'm misstating what your question was, but my understanding is you're saying, what happens if some new crisis or new kind of challenge at the international level that we aren't ready for, didn't anticipate in some way. And I would argue we're living through that right now with the UN Charter. Because if you look at the UN Charter, it is a system that's biased in favor of the status quo in terms of the territory and countries and so on. Right? If you're under the UN Charter, you are not allowed to use force unless the Security Council approves it, or you're defending yourself from an attack. And so I think when that provision is written in 1945, the framers of the Charter, the countries were worried about the World War II, World War I, nation-state wars. What they didn't anticipate was the huge rise in civil wars and loss of life in humanitarian disasters. And so when you have a system where 5 countries can veto any action of the UN, 2 of those countries, Russia and China, happen to be autocracies, which tend to like to veto efforts to intervene in places like, they didn't intervene in, they tried to veto Libya, in the end they chose not to. They're vetoing action in Syria. The UN Security Council wanted to approve action in Rwanda, where 1 million people died, and their lives could have been saved by intervention of, it's estimated, 10,000 troops from the West. This is a system which I think, there's a reason why since World War II, tens of millions of lives have been lost in war, but from civil wars, internal wars, and not from wars between countries. And I think our current system is not designed to actually confront the problem that's really the most disturbing one at the international level. And so I think in that kind of situation, I think there has to be some kind of reorientation and reform of the system. But it would be very hard to do because Russia and China would veto that too, right? They like the system the way it is now. But I think that because of that, we in the West are letting tens of million people die in places in Africa year after year or decade after decade without trying to do anything about it because the system is designed to prevent that kind of intervention.
Yeah. I have questions. The first question I have is regarding the framework that you're advocating for. So you're advocating that states should, the U.S. should guide its policy, its national policy by, with the Constitution in mind, and the idea that states should have control, and we should pay more attention to self-executing treaties or non-self-executing treaties and things like that. I guess the first question then is, would you advocate this, that all the states, all the countries, say for example the BRIC countries, Russia, China, would you advocate they take a similar approach? Is it okay if they also enshrine themselves or stand and say, oh, we have to work based on our existing institutions and conduct our global policy via our existing institutions? That's the first question. And then the second question from that would be, if they did that, wouldn't that place a boulder in the, you know, in the way of international relations and the global approach towards like big problems? So, for example, the issue of globalization, global warming. If global warming was indeed, as you and I know, is indeed a huge problem, if the world is going to come to an end this year, wouldn't such policies or wouldn't that sort of framework cause problems for the world, for us, you know, getting to actually do things about such problems? And finally,
you only get two. Everyone else got one. You got three now.
And finally, and finally, the final question is just regarding, like, I think Mr. Yu was mentioning earlier about the role of Congress in treaty making and everything, and ensuring that that the president, when the president signs a treaty somewhere, Congress, you know, puts that treaty in effect in the U.S. I guess the final question then is, isn't there a reason why the framers of the Constitution committed treaty-making powers to the executive branch? That's all.
Okay, so I'll try the first two, if I remember. Just a quick note. I mean, I sort of made this argument on the first 2 points, which is, I think you're right. I think countries, it would make it harder, I think, to some degree, for global coordinated action. And I can imagine a crisis situation, like I always imagine the asteroid phenomenon, right? You know, the asteroid's coming, we need to do something, right?
Nothing to do.
Don't you watch the movies?
Take a hold.
But suppose there was, you know, some coordinated action, you would have some sort of emergency mechanism that would arise. Yeah. But short of that, I think that, you know, I think that when you're trying to build really interdependent or commitments, you want a really strong political foundation. So I do want countries to make credible, serious commitments. I would now, and it's harder with autocracies. I've spent a lot of time studying China recently. It would be very hard to figure out how to make them really commit because of their system. But whatever the system is, you'd want to figure out a way to make the withdrawal really hard, to make the commitment credible, and also to serve on political foundations. So the other example I'll just cite again, which is I think this is, in my view, the problem with the European Union. They said, there's a problem, we need to coordinate, we need to build all these good things, which they did. They built a lot of great things for Europe. But they just never bothered with the political foundation, and now they have some really weird situations where people they're not even sure who's in charge, and there's a lot of confusion. And that's not a crisis, that's just it's a long-term building process. But I really do think it was a mistake to skip over the hard political work and jump straight to the coordination, solving global problems, where you have time, right? Where there's not an asteroid coming for you, right?
So I would expect other countries to engage in international cooperation consistent with their own constitutions. And actually you would worry about how secure their yes would be if they did something that wasn't consistent with their own constitution. Other countries don't have the same system we do, though. So if you look at Germany, Italy, and Japan, they have clauses in their constitution or case law that says that international law is actually superior to their constitutions, that international agreements like the European Union treaties can supersede their own domestic constitutions. You know, the reason they have those in their constitutions for pretty good reasons. And basically we made them put those things in their provisions, those provisions in their constitutions given World War II. But we don't have a provision like that in our Constitution. About the House and the participation of Congress in the treaty-making power, I think that's a very good point. I think you're quite right, the framers wanted to exclude the House because they thought it was too numerous and that it could keep secrets, and that the President and Senate would be able to more effectively exercise foreign policy and the treaty-making power. But what I don't think they intended to do was to allow the treaty-making power alone regulate things domestically that would normally be handled by Congress. So, for example, you know, everyone seems to acknowledge that a treaty can't appropriate money a treaty can't define it and include in American law a crime. You always need the Congress to pass laws to carry out those aspects of a treaty. It seems to me that if globalization expands and then treaties expand, then you could diminish the normal jurisdiction of the House in regulating domestic affairs. And so I think our solution is a way to balance the treaty-making power with preserving Congress's role in regulating private rights and domestic law.
Two more so that we can stay on schedule, and then we'll all come up and have a mass huddle. Yes. Yes.
Hi. If I understand the argument correctly, America should have a vetting process of how international communities such as the Security Council or any UN organization can implement laws or action in the United States. Yet, when it comes to Syria or Libya, anything the Security Council says should go. So, is there a little bit of some hypocritical elements there, or even American elitist?
I am an American elitist, but I'm just an elitist. I don't have to do it being American. If I had been raised back in my home country, Korea, I would have been a terrible, terrible elitist. One thing is, what I was responding to that earlier question was more about how I think the Security Council with the vetoes and everything, which plays very much to America's advantage, actually is, I think, a dysfunctional system now. I would be much more in favor of getting rid of it and having a broader Security Council with a majority vote, for example, or something like that. So I'm not arguing in favor of preserving America's veto in the Security Council. But I would say that when it came to Libya or any other country, they too should have the sovereign right to decide which international agreements and laws they want to comply with and which ones they don't. So, for example, if another country is the subject of a Security Council resolution, they may have an international obligation to uphold it and carry it out, but domestically as a constitutional matter, they might refuse to do it, and they are in breach of it. Just like the United States might, as we do, sign treaties, and then we don't carry them out, and then as a Medellin, we become in breach of those treaties. But the point is, I don't think that international agreements and laws should override the way that the Constitution sets up the decision-making process for a country. And I would say that's just as true of any other countries of the United States. So I'm not arguing for any kind of double standard. At least it doesn't sound to me like a double standard. It is the case that the United States has more influence in the Security Council because of the veto that another country, a Middle Eastern country, there's no Middle Eastern country that's a veto. So that gives us the ability to block anything that would be imposed on us in the Security Council that any Middle Eastern country or African country or Latin America, I'm assuming none of those other regions of the world have permanent seats on the council. They don't have that ability. I guess that creates more the difference, not the attitude of international law to the domestic constitution.
So do you mind if I pose a hypothetical to you? Let's say if
I know you're a law student. This is your first and only chance to ask me.
So let's say there's a domestic uprising.
Can I pass? If I don't feel like
If you pass, then Professor Kuhn.
I'm done reading on it.
So let's say, for example, there was uprising in the United States, and Syria or Libya want to now come and arm the rebels in America. What would be the process of either can America even is in a position to allow this to occur? What should be the mechanisms to stop this from occurring? Should they be stopped from doing this? How would you approach that issue?
Historically, this did happen in the Civil War, where Britain and France considered aiding the South, and
it didn't happen.
Yeah, it did happen. The interesting thing is that I don't think the United States, the Lincoln administration, I have to go back and check. I don't think the Lincoln administration claimed it would be a violation of international law per se for France or Britain to do it. What they did is they pushed Britain and France not to recognize the South as a country. But it seemed to be they accepted that if the South were recognized as a country, then they were allowed to aid them. But throughout the Civil War, which was contradictory in a way with what the Union was doing domestically in its attitude towards Southerners in terms of fighting the war, where they considered them a separate country and used the laws of war against the South. But with Britain and France, what they did is they said, we're in an internal civil war, there's no other country, so you you shouldn't aid the South because you would be intervening in a domestic dispute. So I think that's the closest I can think of to your hypothetical. But it seems to me today, if this would happen under modern times, I don't, and Julian may be much more expert at this, I'm not trying to pass, but it doesn't seem to me that it would be illegal under international law for another country to help groups in the United States. That would cause obviously enormous diplomatic and political problems, but I don't think it would be directly illegal, but I could be wrong. I mean, because there's a whole Geneva Convention additional protocol about
but
this.
Who cares if there's a Geneva protocol if Congress
Well, we're not a party to it anyway.
So, right, so if the United States is not a party and has not gone through...
Oh no, I actually was raising the protocol to say that I don't think the protocol makes it illegal either. That actually it supports your hypothetical rather than impedes it. But we haven't signed it. But I don't think you could say it's just a violation of international law for a country to help a dissident group in your own country. Is it?
Not international. It would probably almost certainly violate the domestic law of that country. And also, usually sometimes there's a UN embargo which will prevent any country from. And that's actually part of what's going on, I think, in Syria. Everyone agrees not to arm anyone and try to reduce the violence. So.
Okay, last one. Yes.
Awesome. My question, it's kind of three parts to it.
You guys really think you're in charge now? You're the professor.
Part-time. So the first part of it's more of a clarification. I know in the way Ms. Dunliner introduced you and what you said as well, in your proposal, you would treat all treaties as non-self-executing. And I'm not sure if you just said that casually, as though there are more nuances to the way you treat it, or whether you would mean it literally as that. But the second part is, if you would treat all treaties as non-self-executing, my initial impression was, doesn't that fly in the face of what the Constitution says in Article 6? And my memory of Medellin is very shaky, but I did have my Constitution. So, so it does say in Section 2 of it, and I'm always saying this is the same one everybody else has. So it says, this Constitution and the laws of the U.S. Made in pursuant to the Constitution, and as my old professor Leon Friedman would say, semicolon, and all treaties made, or shall be made under the authority of the U.S., are the supreme law of the land. So the way I understood it based on the plain language of the text is, there are acts of Congress and there are treaties, and both of them are quote equivalent in terms of their power. And the argument would go, if treaties needed Congress to validate them in the form of an act of Congress, then a treaty, quad treaty, would not be the supreme law of the land. Then the Constitution would simply say all acts of Congress, or all the laws of the U.S., and exclude treaties altogether. But the Constitution doesn't say that. The Constitution says all the laws of the U.S., semicolon, and all treaties made by the authority of the U.S. So my impression was that treaties are co-equivalents of acts of Congress, and they don't require a prior validation of acts of Congress. The third part of my question is, so if you answer my question, then you go on to the third part. What discretion would you give to Congress to incorporate provisions of the treaty? Is it just unfettered discretion, or could Congress still pass a law that would be inconsistent to the objects of the treaty that it has signed in?
Well, I mean, I think as a matter of practical, I don't think we argue that there can never be a self-executing treaty. At least I don't think we argue that. But I think we argue we're mostly focused, and so we don't engage directly the doctrinal issue. Now, if you're interested, you could read an interesting article written by Professor Yu on this question which in the Columbia Law Review, on the history of non-self-execution and self-execution, which suggests that many treaties would be historically non-self-executing. But I don't think, I basically accept that there are treaties and that can be self-executing. I think the focus of the argument is on the benefits of treating treaties, especially new treaties that we make, as non-self-executing, and this goes to the, I guess, part 3, I guess, which is that some of the benefits. Now, I think you're right that Congress could calibrate this wrong, right? But the problem is so could courts in terms of how they interpret the effect of the treaty. So, in a way, I think Congress, we think, and on this point I think we definitely agree, is in a better position, or at least as good a position, if not a better position as courts, as to figure out exactly what they want the domestic impact to be. Now, could they depart from the treaty? Yes, they could, and they could interpret it incorrectly. But I'm not sure that they would actually do that any more often than courts do when they're applying treaties.
I think it's a great question, and I admire the fact that you actually thought you should look at the text of the Constitution to answer it, which is a very good instinct that not enough people have. So kudos to you. However, I don't think the Supremacy Clause on its plain text makes all laws self-executing. So for example, even they're not just statutory provisions, but in fact constitutional provisions which are non-self-executing, even though in the Supremacy Clause it says, as you perfectly read it out, it said, right, the Constitution, laws of the United States passed pursuant thereof, and treaties. Actually, treaties are in the middle. But even then, the federal court system is non-self-executing. The creation of federal jurisdiction over federal laws, actually the Supremacy Clause doesn't really answer the question, well, if you sign a treaty, then what do you do to make it law or not in the United States, just as it doesn't answer the question for constitutional provision. So you could have had a system that wasn't that, right, that was actually everything in the Supremacy Clause is self-executed, but from the very first day, we haven't done that. That might actually be a more natural reading of the Supremacy Clause, but the Supreme Court has always thought that there are certain provisions of federal laws and the Constitution which don't self-execute. Second thing I'd say is about the, so your next question is, well, if you do think that treaties are non-self-executing, have to be carried out by Congress, then what discretion does Congress have? So this is, again, something that the framers argued about with the very first treaty, the Jay Treaty of 1795, and Hamilton thought that Congress had a constitutional obligation to carry out a treaty. He thought if the country signed a treaty and took on an obligation, it was obligated to pass all the laws and appropriate all the funds necessary to live up to the treaty. Madison, who eventually won, thought that no, the House and Congress didn't have to. They had no constitutional obligation. He thought it would be a bad idea if you didn't live up to the treaty, but that Congress had the discretion not to live up to it. And in fact, in that very first treaty, there was an important provision that Congress refused to appropriate the funds for and so didn't carry forward. So our proposal is really that tradition that the court reaffirmed in Medellin, because I think under your view, Medellin was wrongly decided. But that the tradition that's in Medellin actually solves a lot of these globalization and constitutional law problems, although it might have done so unintentionally.
Okay, everybody, thank you so much. Thank you.